They call the meeting to order. This is the first meeting of the 2020 year of the California Law Revision Commission. I'm Victor King, the chairperson. And since we do have some relatively new commissioners here, why don't we just quickly go and introduce ourselves.
I'm Steve Cohen, Staff Counsel for the Commission.
Barbara Gall, Chief Deputy Counsel.
Kristen Burford, Staff Counsel.
Jane McAllister, Commissioner. I'm from Modesto, California, private practice.
David Carrillo, new commissioner, UC Berkeley School of Law.
Victor King, the chair.
Brian Hebert, Executive Director.
Ana Cubas, Los Angeles College professor.
Crystal Miller O'Brien, Commissioner, and from Los Angeles, in-house counsel.
Rick Simpson, Commissioner, retired from this illustrious building.
Thank you, everyone. A reminder, we are live audio and video streaming. So let's begin. First item on the agenda, minutes from the November meeting.
This is Memorandum 2020-1. The staff has no corrections to offer, but I understand that Commissioner Carrillo has requested that that his name include his middle initial in the attendance. Is there anyone else who'd like to add an initial where there isn't one? No? Okay. So that's the only change I'm aware of, but maybe other commissioners have issues with the minutes.
Any other changes or suggestions by any commissioners?
I'll move approval.
I'll second.
All right. All those in favor say aye.
Aye.
Anyone opposed? Any abstentions? None. Okay. Item number 2. We turn to administrative matters. The report of our Executive Director, Brian.
Thank you. One thing that doesn't directly touch on the commission, but is certainly relevant to the commission, is that, as you know, in January 1, 2020, the Committee on Revision of the Penal Code came into legal existence, and the staff is also supporting that body. It had its first meeting last week on the 24th, pretty successful meeting. They have all of their appointments in place. The membership is, the chair is Michael Romano of Stanford Law School. The other appointed members are former Senator John Burden, Carlos Moreno, retired Supreme Court Justice, Peter Espinoza, retired judge from LA Superior Court, who's also heading up their pretrial diversion program. And who am I forgetting, Byra? L. Song Richardson, Dean of UC Irvine Law School. Thanks, Kristen. I beat you. At the last meeting, I predicted that might be the last meeting where you would see Steve Cohen. Turns out not to be the case. The hiring process, we have 2 attorney positions to fill for that new function. That's dragging out longer than expected, and so his status is still yet to be determined. That's all I had about the committee. With respect to the commission, I was told that Commissioner Rubin will not be here today, and very likely we won't have Commissioner Boyer-Vine. I have, as I mentioned at the last meeting, the possibility of having a more formal lunch. I have made arrangements for that, so hopefully, I'm sorry. We have reservations at 12:30 at the Grange, which is about 2 blocks from here. I'm sorry, Commissioner. The other thing I wanted to mention is that on the original agenda, there was a Memorandum 2029, which was the last item for the agenda, and item 8. That's been dropped. So we'll consider that material at a future meeting. And as some of you have guessed, it's likely this meeting will be kind of short. And I think a big part of that is that Barbara Gall and I are splitting our time between the commission and the committee, and there has been a lot of committee-related work because we're standing up the entity. And so that may not be typical going forward, but at least for that first interval, a lot of our time was spent on that other work. work. And so, as I had expected, we didn't produce a lot of material for this meeting. So the material's a little light. That's all I have for the executive director's report.
Brian, for nomenclature, you and I had a discussion a couple of meetings ago. Are we officially the commission and they're officially the committee? I mean, is that how we're going to be addressing these things?
I think so. As unsatisfactory as that is from the point of like clear differentiation, that's the entity's name, and they've decided that they're going to stick to the formal name, which is Committee on Revision of the Penal Code. Yeah, so I'll shorthand for clarity. Informally, I'll probably say Penal Code Review Committee or something like that, even though it's the revision, not review. Any other questions? Okay, that's all I have.
Next is our section for commissioner suggestions. You can propose any new study topics or discuss our procedures or any other general matters that are not otherwise on the agenda. Any takers on that from any of the commissioners? Seeing none.
Well, but
Oh,
I don't
sorry?
know if we, yeah, I don't know if it may be too political right now. The independent contractor, AB5 right now, if we want to touch that or even look at that, we could possibly lend some clarity to a study to review.
I don't think we have authority. I'm just sort of trying to fill my brain with the resolution of authority, and I don't think we would have authority for that. I've got the statute, I believe.
You just happen to have for our authority.
Well, if not, I can
think
find it online.
Maybe, I mean, it's enacted law. We could look at it for next time. And I'll go ahead and write out some ideas too and do a formal proposal for the next meeting, okay?
That sounds fine.
Sure,
Okay.
that would be fine, because then we can take a look at the specific statutory language.
And then the fact that there's a ballot proposition that everyone says is being prepared for that, there's a lot of moving parts to that law that we may not want to jump in at this point. Next, open government laws, our annual review, memorandum 2020-2.
Oh, I'm sorry too, and one more suggestion too for Brian, for just the, I know that we worked on an employee handbook maybe, or I think we kind of just did some preliminary talk, and I think you were going to work with Ledge Council to maybe consider it, but there's been a lot of different laws that impact employees as of this, January 1st, so you may want to update or do some revisions for.
For the staff?
Yeah,
Okay, yeah, I'll take a look.
just another suggestion. Okay.
Okay, turning to the open government laws.
All right, that's fine. Good morning, everyone. Each year, based on direction from the commission, staff presents a memo summarizing open government statutes, generally relating to the business of the commission. Typically, you'll see the memo at the beginning of each year. This is an information-only memo. It doesn't seek any decisions from the commission. And so, in the interest of time, I won't verbally go through orally go through everything that's in the memo, but I'm happy to try to answer any questions anyone has about what's presented in the memo, or if I can't, research and perhaps bring back an answer at another time. Also, for commissioners who were here last year, the staff found no new developments related to these statutes over the past calendar year, so the content of this memo is substantially the same as it was last year. Any questions?
No questions or comments for any commissioners? Okay, seeing none, we'll move to item 3 on the agenda, the legislative program status report.
Yes, that's memorandum 2020-3, and there is a supplement that I believe I handed out to you this morning. It's early in the legislative year, so the main focus of this memo is my efforts to find authors who would be interested in introducing bills to implement the commission recommendations that are pending. And that effort has been successful with respect to the commission's recommendations. We have Assemblymember Ed Chow has agreed to author legislation to implement the California Public Records Act proposal. And that's actually going to be a little burdensome for him in that it's going to be 2 bills. There's going to be a main recodification bill and a second one with conforming revisions, and his office understands that. We also have a collection of 4 recommendations related to trial court restructuring that are listed on page 2. And Assemblymember Brian Mainshin has agreed to introduce a bill to implement those recommendations. And then finally, with respect to the recommendations, Senator Roth is going to introduce a bill to carry our revocable transfer on death deed follow-up study proposal. The memorandum discusses the fact that there were changes made in the bill draft language so that it varies slightly from the language the commission approved. When we're in this process of looking for authors, the commission staff has authority to request unbacked bill drafts from legislative counsel, and we routinely do that. So that if a member is willing to serve as an author, we can hand them the bill draft and they can just put it across and have it introduced. We often are involved in sort of a negotiation with legislative counsel about the language that goes into the bill draft, because their drafters have their own standards and practices, and they often make changes to conform to their own style preferences, and that it wind up being slightly different from what we propose. We try to anticipate that when we're drafting our language to the extent that we know what counsel's practices are. We try to employ them to avoid that kind of distancing. But we were caught flat-footed with respect to a few things this time. And so the memo describes some of the kinds of changes that were made in bill drafts that we did not resist. So when the bill is introduced, the language will be slightly different from what was approved in our recommendation. The staff's recommendation for all of those is that the commission's recommendation be conformed to the bill draft before it's formally published in a bound volume. Because it hasn't yet been formally published, we call it a preprint, which means its content is still changeable. And all of the changes that were proposed, well, I think there's one exception that I'll talk about in a moment, but for the most part, all of the changes that were proposed were non-substantive. It was just that the Legislative Council prefers to draft something one way and we drafted it a different way. An example of that came up a few different times was we would make substantial revisions to a code section using strikeout and underscore to show how we were changing the language. It's their drafting preference, if the changes are significant enough, to simply repeal the provision and then add it back with the language, final language that's proposed. So that's an example of the kind of thing that they changed. And it really doesn't affect the meaning or outcomes under the law at all. So before I turn to the one exception to that, I noted this as consent. I presume that that was okay. If anyone sees it differently, they should let me know now. Okay. The one item that I don't believe I put on consent, and I think my thinking was that I still think it's quite technical and routine, but it is new, and I also think it's instructive for the new members who may have less experience with the legislative process to talk about this in a little bit more detail. In the trial court restructuring bill, Mr. Mainshin's bill, the staff proposed, and the bill draft contains what we call a subordination clause. In terms of how the legislative process goes, it happens quite often that two bills will seek to amend the same section in the same year. And then you have a conflict between those two bills, and there have to be rules for how those conflicts are resolved. And there is a statutory rule that unless the law provides otherwise, the later chaptered law controls. So whichever one is signed last controls over the one that's signed earlier. Legislators get around that through a practice of comity. They cooperate with each other to draft what's called double jointing provisions, which are really just complicated alternative contingency rules that say, if that bill over there gets signed into law, and we're the last one signed so that we control, we're also going to include their proposed changes, right? And then they do that reciprocally crisscross. So that happens a lot. It's tedious and complicated and presents a risk of error if you do it wrong. So it is a common practice when you have a bill that's likely to produce a lot of conflicts and its content is entirely technical, to put in a subordination clause where you say, regardless of which bill is signed first, we yield to all other bills in the event of a conflict, right? They win. Everybody else does, because we don't want to accidentally knock out of the law a hard-fought compromise provision substantively affecting the law because we made a technical correction. So we do that kind of thing with the expectation that where there are conflicts, the provisions are just going to get knocked out of our bill, and we'll come back the next year and pick them up and reintroduce them. So that's what a subordination clause is, and we've got a bunch of technical bills on our plate right now, so that's a routine feature of it. And I just wanted to give that explanation. And I guess formally say, is that okay that we added this to the trial court restructuring bill? Yeah. Okay. All right.
Double jointing becomes even more entertaining if there's 3 or 4 bills that all amend the same code section.
Right.
Imagine that, all the contingencies.
Yeah, because then it's like third and fourth dimensional crisscrossing contingencies, yeah. The only other thing I'd note is that we were also seeking an author for the Commission's resolution of authority. We were required to have this at least once per session. And this year, we were actually going to be asking for a bunch of authority grants to be knocked out as obsolete. I asked one of the judiciary committees if they could author it for us and found out very late that they weren't able to. And so I was left without an author. There's still the possibility that there'll be somebody who will pick that up for us, but I'm not counting on it. And it's, as I explained in the memo, this isn't a problem because we weren't requesting any new authority that we needed in order to do work in 2020. We can continue to rely on the prior grants. It's just fine. And we'll just come back next year and I'll make sure that I get an individual author lined up for this next year so it's in this legislative session. That was all I had on that.
So we're now turning to our substantive memo. Disposition of estate without administration, that's memorandum 2020-4.
Right. So a little bit of background for commissioners who are new to this topic. There's mention, I think in this memo more than once, to the revocable transfer on death deed, and I want to explain why that is. The revocable transfer on death deed was enacted based on a commission recommendation. It took several attempts to get it passed, but it eventually did pass, and it was amended substantially by the legislature, but it was grounded in the commission's recommended language, and for the most part based on the commission's recommended language. When we were doing that study to figure out should there be a revocable transfer on death deed, the former executive director, Nat Sterling, did that study, and he just did a comprehensive review of, like, we're creating a new conveyancing instrument on death. Let's think through all the operational and legal implications of that and try to address them all. So one of the ones that was addressed was if you use an RTOD deed to transfer your home on your death, what liability do you have for the deceased transferor's obligations? If you went in probate, the property would be liable for creditor claims and a bunch of other obligations, financial obligations of the estate. Should that also be true to some extent for these RTOD deed? And the commission decided that yes, the RTOD deed should be liable for the deceased transferor's unsecured debts. And the proposal, which was part of what was enacted, included some provisions establishing that principle and providing mechanisms for effectuating it. And in drafting those provisions, Nat Sterling borrowed from another body of law. provisions that allow, in specified limited circumstances, certain property to be taken out of a decedent's estate without probate administration. So personal property taken from an estate whose total value is below a dollar threshold, or real property where the value of that property is below a dollar threshold. You can take that out without it being part of the probate administration. And when that law was enacted on the Commission's recommendation, the Commission had the same analysis, that the fact that you take this outside of probate should not immunize the property from liability for the deceased transferor's debts. You should, as the person who receives that property, remain liable for the decedent's debts up to the value of the property. And again, provided mechanisms for effectuating that. Well, we borrowed that law for the RTOD deed recommendation, almost verbatim. And so when we were conducting our follow-up study of RTOD deeds, we received helpful comment from the Trusted Estates section of the California Lawyers Association, maybe the State Bar at that time, I don't remember. And there were a lot of technical concerns that were raised about the RTOD deeds liability rules. And we analyzed those and we addressed them in our recommendation on that study. But the same issues applied with equal force to the source law, these provisions that allow you to take property without probate administration if you're under these dollar thresholds. So we launched a separate study of that related law and analyzed the same issues. And we had a tentative recommendation on it. We received comment from TexCom, the Trust and Estates section. That comment is discussed in Memorandum 2024. The memo raises a few new issues, and so we got a subsequent letter from TexCom, which is discussed in the first supplement to 2024, which you should have received by email, but it was also handed out this morning. And so the point of this memo is to walk through the issues that are raised by TexCom's commentary and see if we can make enough decisions to get into a point where we're comfortable directing the staff to come back at a future meeting with a draft of a final recommendation for your review. So I'm just going to walk through them in the order in which they're presented in the memo, if I can find my notes. Well, maybe I'll just do it from memory.
You take a break if you need to, Brian.
No, that's all right. This is pretty fresh. So the first thing that came up in the memo was a technical issue related to terminology. And this is addressed, well, okay, first of all, there's an overview of the proposed law. And it might be helpful for me to just summarize that briefly before getting into the specific issues. As I said, the general principle is that these rules that allow you to take property without administration are not intended to immunize that property from liability for debts. You're intended to remain liable to the same extent that you would if the property had been part of the estate. It's a convenience for you. It's not intended as a shield. Because if you did immunize the property, you'd be unfairly burdening the remaining beneficiaries whose property stayed in probate because they'd be liable for a greater share of the debts and you would have skated. So the rules we're looking at are statutes that establish the personal liability of the transferee to the decedent's unsecured creditors. So they can go against you personally. If you take this property out, a creditor can sue you directly. As if you were the decedent, okay? There's also a rule that makes you personally liable to a person with what's called a superior right to the property. That means you took the property out of the estate under one of these procedures, but as it turns out, you shouldn't have. It wasn't supposed to go to you. Another person is the person who should have received it, and that's the person with the superior right. In that case, you are personally liable to the person with a superior right. And those rules are, I think, mostly or entirely going to operate if there is no probate. The decedent's estate is not being administered. So maybe I took the only asset out of the estate under one of these procedures. And so you've got these individuals who are aggrieved, creditors or a superior right claimant. They can just sue me. They don't have to open a probate to do this. Then there's a third rule that says if there is an estate that's being administered, so a probate has been opened for other assets or for other purposes, the personal representative of the estate can require you to return the property that you took to the estate for use in paying debts or for disposition to the person with a superior right. And then finally, for the purposes of this memo, the last piece that we're talking about is that if it turns out you took the property improperly, you should not have been the recipient, and you did that fraudulently, you can be liable for treble damages based on the value of the property. And that's true whether a superior right claimant is suing you personally or whether the estate is requiring you to return the property for disposition to a superior right claimant. In either one of those instances, you can have treble damages. Or returning it to the estate for payment of debts, I believe. Right. Yeah, under existing law. Okay, so our reforms that we're proposing, probably the most significant one is that we're limiting the rule that allows the estate to claw property back so that it would only apply in the case of a superior right claim. You could not do that for payment of debts. The reason being that you might have a situation where that's really an overly burdensome mechanism. The debt is $5,000, the asset you took is worth $50,000, and it's not liquid. You give it back, they sell it, and now you don't have the asset that you wanted, and maybe it was a keepsake or whatever. So we took out returning the clawback, returning the property for payment of debts, and we replaced it with instead a rule that says the person who takes the property is personally liable to the estate for a calculated share of the debts. And the calculation is based on the fiction that the property had remained in the estate. So you apply all the rules that would have applied to it if it had been in the estate. And they calculate how much you would have owed, and maybe it's nothing, because there are these priority rules about which assets get used first. But you write a check for that amount and you're done, and you get to keep the asset. So that's the sort of the heart of the proposal. Eliminate the clawback for debts and provide this more nuanced alternative approach for debts. We also added in a rule that you can just voluntarily reverse having taken the property out. You can just return it. There may be situations where that's just the easiest thing. You regret the decision that you made. It's creating complications you hadn't anticipated. You just give it back and it'll be probated. And then we also made some technical changes to make improvements to some technical rules about how the property is valued. And we'll get into that. Okay, so TexCom's comments were generally favorable, but they had some specific issues they wanted to talk about. As I said, the first one of those has to do with terminology. There are two statutes. One is for personal property in a small estate. The other is for real property of small value. We created definitions in those laws for ease of drafting to replace long phrasings with short defined terms. And very parallel, but the language in existing law is slightly different because of the difference in process under those two laws. And so we wound up with two different defined terms. One was transferee, the other was designated successor. And then, as I said, it was reasonable to take that approach because the language that was being replaced sort of correlated to the term that we wound up with. TexCom's first comment was they think that's potentially confusing, that it would be better for both of these very similar statutes to use the same defined term, transferee. That's certainly possible. You can use whatever term you want for a definition. And I see their argument, and they also made a separate argument that it might be confusing to talk about designated successor because in the language that's being replaced, the designation is made by the transferee, the person who's taking the property designates themselves as the successor in a document, and that's the designation. TXCOM's concern is that people will think, oh, that means the person who died designated them as the successor, and that implication would be wrong. So they think it's cleaner and easier and less prone to confusion to use transferee in both cases. I wind up agreeing with them, and so the first decision is, would you be comfortable making that change in terminology?
Yes. Okay, it's unanimous.
Okay. Thank you. The next issue. Yeah, okay, sorry, this is going to be technically kind of tedious. This has to do with how the property is valued, okay? So, and there are different situations in which valuation arises, and there's three, and they're kind of different. And TXCOM is concerned about the proposed law's date on which you make the valuation, okay? The first situation is under this new proposed law that is not existing law. It's the Commission's proposal that would provide that when there's an estate open, the transferee is liable to the estate for a calculated share of their liability as if the property had stayed in the estate. So that's the first context. In the draft language, we say, and when making that calculation, when figuring out how much the transferee owes, value the property as of the date that they received it. TXCOM points out that in probate and in related proceedings, like allocation of estate taxes, the date of the deceased transferor's death is used for valuation. And they say this is going to cause problems if when I, the personal representative, get this asset back and I'm looking at this asset and I'm looking at everything else in the estate, this is valued at the date it was received, this is valued at the date of the decedent's death. The reason that's a problem, as explained in here in kind of tedious detail, is that there are rules for allocation that require pro rata distribution of liability. So you might have two assets that are in the same, what's called an abatement class, so they're both going to be used to the same extent for payment of debts. You divide their liability pro rata, and so that depends on the size of the gifts at issue. If one's worth $100,000, the other's worth $50,000, this one's going to pay twice as much debt as this one is under pro rata principles. So if you've got an inconsistency in the date of valuation, that can skew the pro rata in ways that wouldn't happen if all the property had stayed in probate. If it had all stayed in probate, it would all have been appraised as of the death of the deceased transferor. But if I take it out, its value for the purposes of pro rata allocation could be very different depending on whether there's been change between when the decedent died and I got the property. So I think their proposal, or I don't know if it was an affirmative proposal or just pointing out a potential problem, but my conclusion is that is a problem, and it is at odds with what the general principle that we're proposing, that the property be made liable to the same extent as it would have if it had stayed in the estate, had not been taken out. And that point they make is at odds with that because it wouldn't be the same, it would change. So my recommendation is, I think this was an oversight. I don't think we talked about this. I don't think it was intentional that there be that inconsistency. And so my recommendation in the memo is, let's remove the special rule that says you value the property as of the date of receipt. And with that rule removed, then the general rule would be you treat it as if it had stayed in the estate, and so it would be valued in the same way as other property in the estate. What do you think about that? Is that okay?
I'm looking at you, Jane, because, I mean,
Well, I think it's absolutely So I think it's absolutely makes sense because that's pretty well-established rule of law. Valuation has been as of date of death for assessment purposes. It's well established in the law, and it would cause a lot of confusion. And also, there would be a lack of parity
Right.
for beneficiaries. So I think it's a great idea. And I don't believe we did discuss it, so.
No, I
We
think
should
I
change
I
that.
overlooked it.
Honestly, I think that we thought it was logical to do it at the way that we have it, because, I mean, you could have a situation where it does make sense not to value, like if you had these non-traditional relationships, with stepkids or whatever. So it's kind of like if you took the time to do a revocable transfer on death, then why would you treat it the same as you would had it gone through probate?
Well, this is not a revocable transfer on death. This is taking property out of the estate. The beneficiary's action is what does it. The testator didn't authorize it. They just died. They said, Crystal gets half my property. They said this in their will. And then Crystal shows up and says, well, it's under the dollar threshold. I'm going to take it without probate.
Because I was reading this as us still just filling in basically the details on our revocable, our RTODD work.
No, this is us working on the law that was the source of those details.
All right. Then it needs to be
And the other
imperative.
thing that I think, and this is really kind of extrapolating this idea, that what if someone refused to take it? It's a highly appreciable asset, and they kind of delay taking possession of it, and it changes the value, or the value declines. I
No,
think it's
it
just
could
too, that sounds kind of Machiavellian, and I'm not saying
Not
that's going to happen, but it's better to have a bright line and have it be easily ascertained by everyone who's involved and have just a common standard, in my opinion. So I would be in favor of that change.
Okay.
You're an okay?
Yeah,
You're
I'm
an
okay
aye?
with it.
All right.
I'm okay.
I don't hear any no votes or abstentions. Okay.
Yeah, but I was looking forward to I wanted discussion on that and I have all these question marks because I'm like, well, that doesn't.
Makes
that
sense
was
to
the
have
whole
question
point.
marks. This stuff is technical. The next context in which something comes up about valuation, and this may be part of what you're remembering too, because there are these rules where the law says that if you take property, if you're a transferee, you are liable to the decedent's creditors, personally liable. You're also personally liable to a person with a superior right, okay? Your liability under those rules is capped at the value of the property you receive, right? And that makes sense. It's equitable. You shouldn't have greater liability than the size of your gift. As a consequence of getting the gift, you would say, no, thank you, I don't want the gift. And then the third situation is that there's also, when you calculate the treble damages I mentioned for fraud, it's based on the value of the property, 3 times the value of the property. In all 3 of those rules, under existing law, it is the date that you receive the property that is used for valuation, not the decedent's death date. So we asked Texcom for comment about this, and in particular, I was interested to know, as a practical matter, how does this work in probates or in trust? If there is a situation like this where the value of the property changes over the course of administration, what consequence? And they provided what I thought was a really helpful example. Let me stop, because first I want to introduce their concern. The concern they raise is that if these rules continue to use the date of transfer as the valuation date, you're going to wind up having to pay for 2 appraisals. There's going to be inefficiency of 2 appraisals. For the purposes of probate, it's going to be appraised at the time of the decedent's death. For the purpose of application of these rules, it's going to be appraised at the time of transfer. That's going to double that procedural burden. The contrary point that the staff made, and we don't dispute that that's an issue and a legitimate issue, but we raise another concern that kind of cuts the other way, which is equity. If I receive a gift from the decedent's estate that's worth $20,000, it makes sense that my exposure is going to be $20,000. What happens if there was a change in the value of the property between when the decedent died and when I actually got the gift? What if the value was 20 when the decedent died, but the gift I got was 10? It went down. There was depreciation. Now I'm liable for $20,000 in debt for having gotten a $10,000 gift. Or conversely, it went up, and it's now worth $40,000, but I'm only liable for 20, and that leaves the other people in the estate sharing a larger burden. So there's a weird, there's a potential for mismatch that could be inequitable in some circumstances. So those were the two concerns that are discussed here. The examples that TexCom provided, which I thought were really helpful, are procedures in probate, and there's one in trusts that is slightly different procedurally, but fundamentally the same for our purposes. In probate, the personal representative is supposed to give notice to known creditors. If they don't, and part of the purpose of that is like foreclosing creditor claims. This is it. This is your opportunity. It's a short window. Come with your claim now and we'll settle. And if you don't, you're barred from bringing it later. Unless you didn't get notice, and the personal representative should have sent you notice, but they didn't. In that case, you're not barred. And the provision that they cited specifically says that even after the probate is closed and the property has been distributed, the creditor who should have gotten notice but didn't can go again personally against the people who received property from the estate. And under that rule, the value of that property, for administration purposes, the value of the property is the date that it was distributed, not the date that the transferor died. That to me feels similar to the provisions that are at issue here, and it seems to make the same kind of sense that you shouldn't have greater exposure than the value of the gift that you received. So I think that that tips slightly in favor of existing law, which values it at the date of transfer rather than the date of death. Does TexCom, we have a representative here from here. I'm not going to out him by name because Open Meeting Act, I'm not supposed to do that. But if you have comments on this or any other point as we proceed, you know, just let us know.
Thank you. Good morning, Commissioners. I will chime in if there's something. Feel free to ask questions of me as well. So far, your explanations, Brian, have been on point, so I don't have anything to add to what you said.
Well, and based on the latest submission, the second letter, and the content I just discussed about the examples you gave, and my sense that it weighs in favor of preserving the existing rule, do you think TexCom has the same sense?
I think generally, yes. I mean, first of all, I'd say this TexCom is not going to have strong feelings about what choice the commission makes in terms of valuation date. So, you know, we provide and even in our first letter, I don't think we made an affirmative recommendation.
Right.
We just made a comment. You know, I could envision a situation where, you know, you could have still date of death for purposes, for example, of determining the value of property for a share of claims or for other technical reasons, but still retain the provision saying that the measure of the transferee's liability is determined as of the date of receipt, basically.
So the staff recommendation, after having received the additional input from TexCom, is that we not make a change to those provisions. We leave them valuing the property as of the date the asset was taken. Is that all right? Sure. I found my notes.
Let's see unanimous.
Okay, thank you. I don't hear any no's or abstentions. The final instance where valuation comes up that's discussed in the memo is if the transferee is required under the clawback provision to return the property and they no longer own it, presumably because they sold it, because what they have to give back is the proceeds of sale, what they received as a consequence of having sold the property on. That necessarily means it's being valued at the time that they actually sold it, because it's the actual value. It's not even an appraised value. And so in the memo, I say, well, let's look at the equities of this. Does it make sense if there has been a change in the value of the property between when the decedent died and when the beneficiary sold it? And it's going back to the estate, perhaps to go to somebody with a superior right claim. Is it fair to that person who should have received the asset from the beginning to bear a loss or realize a gain if the value of the property changed before it was sold? And I differentiate between two situations. One, as I say, if that change was the result of market change, then yes, I think it makes sense that the person who actually should have received the property should realize that change. Because if the property had stayed in the estate and been distributed to them, then they would have been subject to the same market forces. The other case, though, is where the transferee, their own actions changed the value of the property. So like they encumbered it, and now there's a secured debt against it that wasn't there before. That should not be borne by the person with a superior right. And fortunately, we anticipated this. In the proposed law, there are adjustment mechanisms that say if the transferee is required to return property to a superior right claimant and they burdened it, then they're liable for removing those burdens. If they improved it, then they get compensated for their investment that improved it. So you try to do status quo ante. So I think that handles the equitable concerns about change in value between when you got it and when you sold it. So staff's recommendation is leave it the way it is under existing law, which is you return your proceeds of sale. You don't go off some other valuation date.
Yep.
Is that okay? Any questions? Or okay.
I do think that it helped that, like, a lot of us are litigators, and then I think at the time, so we're trying to anticipate the fights that would come out of this, so I think that helped us.
Well, and a lot of what we're doing is based on the original commentary from Texcom on the RTOD deeds, so we benefited greatly from their input here. Next issues on page 11 of the memo has to do with income derived from transferred property, and this is similar. If you're required to return the property, do you also have to return any income that you derived from it? The existing law says yes, you return net income. Originally, Texcom asked us to help clarify what is meant by net income, so we came up with a more nuanced approach that says you have to return income that would have been received by the estate had the property remained in the estate. So if it's like automatic payment of dividends or something that is just directly derivative of the asset and would have gone to the estate if they'd kept the asset, then yeah, you have to return that. If it's income you received that would not have gone to the estate if it had remained, like I am now using this as a part of my business and through my initiative and related investments have realized some gain, well, that you get to keep. You don't have to return that to the estate. So that was the rule the commission proposed. Texcom's pointed out that we were inconsistent. We created that more nuanced income rule and applied it to the property return provision, the clawback provision. We didn't also apply it to the rule that says you're personally liable to a person with a superior right. Okay, there is an income rule in that liability provision. You're liable to the person with a superior right for the value of the property and net income received from the property. So Texcom, I think, correctly points out that that's not ideal for us to have solved this problem on one side and left the problematic language intact in this other provision. The staff's recommendation is that we clone the more nuanced rule and apply it in this other situation in which the same issue arises. Questions? Okay, not hearing any objection. Sounds like consent? Okay. Okay, now we have a genuine consent item that I'm not going to talk about, which is a question that we asked about the operation of a similar law that governs property taken by a surviving spouse. That's on page 13. I'm going to skip over that unless somebody wants to talk about it. Okay. And then, oh, okay. This is going to be a good one. One of the issues that has come up, and we actually addressed it in the RTOD proposal because it came up there first, I think, was what does it mean and what should it mean for a person who receives property outside of probate to be liable for the unsecured debts of the decedent? Under the probate code, there is this statute that lays out certain kinds of obligations of the estate. And unsecured debts, I believe, is one of them, but there are others. And so there is a suggestion that unsecured debts that these others are not concluded in the term unsecured debts. They include funeral expenses, expenses of the decedent's last illness, wage claims against the decedent, expenses of administration, cost of probate, and what's called the family allowance. And so we address this issue in the RTOD proposal by expressly providing that the person who receives property with an RTOD deed is liable for unsecured debts, which includes funeral expenses, expenses of last illness, and wage claims. But we left out expenses of administration and the family allowance. In this study, which is paralleling, there's the same parallel policy questions. It came to us late as we were almost finalizing the tentative recommendation, so all we did was put in a question. We want comment on these issues. TexCom has provided comment, and I believe your general position is you think that the transferee should be liable for all of those things so that they would be in the same position that they would have been if the property had remained in the estate.
That's basically it, right?
Yeah. So with respect to making the transferee liable for funeral expenses, last illness expenses, and wage claims, TexCom is in agreement with the Commission, the decisions that were made with RTOD deeds. So the only difference is expenses of administration and the family allowance. I'll talk briefly about the family allowance first. The family allowance is a law that says during the pendency of administration, the court has discretion, and I don't remember whether there were bounds on that, but the court has discretion to award basically cash payments to the surviving spouse and minor children for their maintenance during the course of the probate. So that while the court is grinding its way through and before distributing assets, the surviving spouse and minor children will be able to keep their head above water. They'll get an allowance from the court. The staff, in the context of RTOD deeds, and again here, the staff offered the suggestion that because of the way the family allowance works, it's really an expensive administration. Mm-hmm. That it's not a family protection in the vein of some other family protections, for example, the probate homestead that just says, you can make sure the surviving spouse and children get the family home. They're going to get it no matter what the will says. The court orders it and it happens. Mm. This is sort of, we're going to make sure they have enough money to get them through this process, however long it takes. And so the amount of money is going to vary about the duration of the probate, and it's really tied into the process. And so we analogized it to an expensive administration, and we recommended that expenses of administration and the family allowance be treated in the same way. So now, what about expenses of administration? The staff distinguished in the memo between what we call general expenses and extraordinary expenses. So an example of extraordinary expenses, the relevant example of extraordinary expenses, is the cost incurred by the estate because the person took the property out of the estate. So they took the property out, now the estate has to tell them what their share of liability is. They're going to have to do some operations. That's going to cost money. They might require an appeal to the court for resolution of a disagreement. That's going to cost money. All of those expenses that resulted from the fact that I took the asset out would be borne by the person who took the asset out. So that leaves everything else. All the general expenses of administration that would presumably be pretty much the same even if the asset was in the estate. And the question is, should the person who takes the asset out be liable for those general expenses? On the RTOD deed side, the commission decided no. And I think the reason was, as discussed in the memo, that one of the main points of non-probate transfer mechanisms is avoiding probate. Well, you don't avoid probate because you're scared of courts. You do it because you don't want to pay for it. And you also don't want delay. I think those are the two main things, cost and delay. So if I'm taking an asset out because I want to avoid the cost of probate, and then the law says, nonetheless, you're liable for the cost of probate, what have I gained? Now, there is a case where you have a good answer to that question, which is if all the assets of the estate are taken out without probate, then you never have a probate, and so you are realizing all those savings. You're never going to have to pay costs of probate if there isn't one, and you use these mechanisms to make sure that there isn't one. It's only if you take something out and there is an administration that this question arises of whether you should be liable for a share of the cost of that proceeding. My intuition is that seems counter to what this is for. Although I understand Texcom makes some good arguments about there are things that are general costs of administration that are going to redound to the benefit of the person who takes the property out. For example, the process of giving notice to creditors and evaluating the validity of their claims. That's a general cost that's going to be used in the process of calculating the transferee's share of liability. That's a legitimate point, and so you're going to have to think about sort of how to balance these things. And the last thing I have to offer is that I did look back. As I said, these laws were enacted on the Commission's recommendation. So I went back and looked at the Commission's recommendation on these provisions and found general language talking about what they were for. And with respect to the estate of small value and personal property, the policy of avoiding costs and delays of administration when a small estate is involved by permitting all entitled successors to collect personal property by affidavit or declaration. So we said the reason we have this policy, this mechanism, is to help people avoid the costs and delays of administration. And then in the provisions that govern real property of small value, if a decedent dies owning real property of minimal value, such as a desert lot or speculative undeveloped mineral rights, the property is sometimes abandoned by the decedent's heirs or devisees because the cost of administration may exceed the value of the property. So if we were to tweak this process to re-import the cost of administration into the process so that the people who take these kinds of assets wind up being nonetheless liable, that specific policy would be defeated. Right? They would still abandon those assets rather than bear the greater cost of administration. So I think to me, it seems clear that the Commission, back when they were proposing this law, had in mind as one of its major elements the goal of helping people to avoid administration costs. Mm-hmm. And so I would be leery about reintroducing those administration costs at the back end by saying, yes, you took it, it's not administered, nonetheless, you're liable for the cost of administration.
Yeah, I agree. I think that one of the paramount things in any kind of estate planning is that the testator or the transferor's intent is paramount. And I think that what you would be doing if we included that, obviously the transferor is intending for this piece of property or whatever is being transferred to transfer with minimal expense and with ease to the person they want to have it. And so I think you could certainly make a public policy argument that you're negating the intent of the transferor. I don't think it should be included personally, so I agree with the recommendation of staff.
The only point I would make in response is that that's definitely true for RTOD deeds. But again, this is something I said to Commissioner Miller O'Brien. Here, we're talking about something that the testator didn't control.
Existing law.
True.
This is the beneficiaries chose to use these procedures.
True.
Does the gentleman from Texcom have any additional thoughts that you've had since your original thoughts were conveyed to us?
No, I think we've conveyed everything that we wanted to say in our two letters. But I would just maybe make a distinction, between RTODD and this situation. With the RTODD, the decedent had made an effort while they were living to do something that was going to reduce the burdens of administration for their intended recipient. Here, the decedent either made a will or didn't make a will. These provisions apply one way or the other, and it just happens that the estate is small enough where the transferees can take advantage of these mechanisms. So I think there's a distinction to be drawn there. Let me add that Texcom does not feel strongly about this issue either. So whatever the commission decides, I don't think we would have a problem with that. And also, I would add that I don't think there's going to be a perfect answer that
Right.
Perfect statute that works perfectly in all cases. So I think choices will have to be made, and whatever.
And
There's probably benefits to one, benefits to the other, and you just have to make whatever choice makes sense.
What, I'm sorry.
Go ahead.
No, what I would think then in this situation, so under under existing law, so if I decided to take, to live in Aunt Betty's trailer on the desert lot that I think everyone forgot about, if the property is probated, if a probate case is open, then the court would have to decide anyway, and usually I think that the court would look at intent and need and means and ability, and they would probably side in public policy, in favor of public policy. So I think our interests are still protected. I think that we're still in the same situation where you're not going to be penalized if you're a spouse, which I see them, and Victor, you probably do too, where people just take payroll checks, and they use them because they need them. And they don't have a right to do that, and they haven't, or they live in the house that they probably already lived in, especially for autistic kids, and they're living there, or they have some type of special needs or whatever. That's what people do. And so if there are other siblings or other family members who have a problem with what's happened, then I wouldn't necessarily add onto the burden the cost of administration and all of this these are penalties, really. It's punitive. It's not, when you look at law and equities, this is not coming out of equity. This is penalize people and require them to wait for probate and to get clarity. But, that's years later. And that's assuming that people have the funds to do it. Like, Brian said, a lot of times people just abandon it because they know they don't want to face all that.
I have a question for those of you who have experience in probate and estate law and proceedings. How common is it that you would have these kinds of situations? In terms of the percentage.
It's hard to quantify that because when you have transfers outside of probate, those really aren't tracked by anyone because they're handled, either they don't go through any sort of administration that would allow you to quantify them. I will say that people do this all the time. They do it with bank accounts all the time. They have a, beneficiary on death for they don't put someone on as a joint tenant per se, but they put someone on my death, my bank account will immediately transfer to. That's designation on death is very, very common. And there's just no way to know that. I did want to say that.
And if I can just share, just for her too, a lot of the cases and the way that law we study cases that have been published. So what Commissioner McAllister is kind of referencing, and that's kind of why we looked at Texcom too, is a lot of times people manage these things through small claims court, or they just fight, and it's just the family that doesn't talk to each other anymore because they don't know what to do and they don't have the resources. So we can't really rely on case law that can help give us guidance on a lot of this stuff. And so we kind of look to their body, their area of law, because they see the people that come and who decide not to go forward or not. So they, so they are very helpful to us.
And by law, these are small sums, right? They're limited by law to small amounts. So that's another reason why nobody's going to pay for litigation or an appeal, because they're dealing with an asset of small value. And Texcom, in their feedback to us, have said that they don't see this very often. I think that probably a lot of them are very informal, like what you're talking about, where it's just like a checking account with $10,000 in it. And then another situation is
Final paycheck. That's
Very, very informal. People will work it out without having to do it. I do think
I'll
that.
have employers that will say, we're cutting a check, Crystal, they can't even afford the funeral. I don't want to drive by
Right.
them with them collecting money.
I do think there's equity in the recommendation for that extraordinary expenses be accounted for. And because that directly is tied to that transaction as opposed to the entire scheme of the estate. So I think that feels like a good balance, in my opinion, because you're trying to make sure there's equity on both sides.
Right.
I don't know how the other commissioners feel about that, though.
so that's in the proposal now.
Right, and I
Right.
like that. I
So
think it's
what I need guidance on is whether you want to change the proposal to make the transferee liable for what I'm calling general expenses of administration and the family allowance.
I would vote no.
I think you have consent with what the staff recommended.
Anyone see it the other way? Or
No
abstain?
opposition?
Okay.
But I
Okay.
do thank you for bringing that up, because you're right, we hadn't, it's true, we were like trying to look at RTOT, but it's a different world, but it's still, the same results should work out.
Right. I don't know if this is an appropriate time to bring this up, or if it later would be a better time, but one of the things, maybe this is kind of a new comment, but in a footnote to our most recent letter, we kind of raised the question about whether, and this may be more relevant when you have an actual restitution property to the estate. I can envision the question coming up if there is a probate estate and property has been claimed by one of these procedures. The personal representative, and particularly the attorney for the personal representative, is going to ask, well, shouldn't we get to base our statutory fee on the value of that property that was taken outside of the state? That is an issue I can foresee being raised, and so I don't know where in the
And that's
context of our
reasonable, too.
discussion.
Well, let's talk about it. They did raise this, and it is for the first time, but we talked about it amongst the staff too, which is that under existing law, I believe the personal representative's fees, the attorney for the personal representative's fees, and the probate referee, I think all of their fees are based somehow, either as a percentage or there's a table, I think, for probate referees, based on the value of the estate. So if you take the asset out of the estate, you've just taken value out that's going to reduce the fees of all of those folks. And to some extent, that makes sense, right? Because if the logic underlying those fee provisions is that there is a relationship between the size of the estate and the complexity of the estate and what's reasonable as a fee to be paid for its administration. Now, so I don't see any problem if you have a non-probate transfer or one of these mechanisms take an asset out that you don't get to charge fees on that asset that wasn't administered. I think where you're coming from is, well, what if it's given back? Right, as a starting point, let's start there. What if it's given back, especially if it's given back for disposition to a person with a superior right? Then it's as if it's being probated. And there's, whatever associated cost with managing that asset is now part of the administration. I can sort of see an argument there that if it's voluntarily returned to the estate, for sure. If it's involuntarily returned for disposition to a person with superior right, then it's as if it's in the estate and it should be included in the fee valuation, I would think. Where I don't agree is if it's out of the estate, but the estate has to calculate the share of debt, right? And there's a way to price that in as an extraordinary expense. I don't think it has to be included in the general expenses, and I think if you did, you'd sort of be double counting it. So I guess there's a possibility for the commission, if you want to see this in a final recommendation and then decide whether to approve it, is we could add language that says, to expressly state, if property is returned to the estate either voluntarily or involuntarily, it's included in the value, in the fee calculation. Because then it would be part of the corpus, just like everything else.
That makes sense, because there would be fees associated with it specifically as part of the entire state.
Yeah, because the administrator would have to deal with it, the court, everyone else would. But if it's involuntarily or voluntarily returned.
Yeah. Voluntary is easy.
So if they
That's-
maintained it, I guess then it would be without objection, but still, it should be part of the estate, the total cost, because if you're the attorney and you're working on all of it, you'd have to do research on what the rights are, and you'd have to give advice on it. I
Yeah.
don't know. I think you have to look at the total estate.
And for the record, we're not taking a position, but I think it's
Sure.
should be clarified,
Yeah.
because I can envision the question arising.
I think that's right, for sure.
Appreciate that comment.
I think it's fair. I mean, so you have an estate where the spouse took the house and you guys weren't too upset about that taking. But at the same time, as an attorney, you do have to figure out,
Yeah.
do they have to do it? Is that okay? Are the parties okay with it? Is the probate referee okay with it? It's a lot of work.
So would the commission be interested in seeing that included in the next draft? And I would flag in the memo that it was new and that you should give it particular attention to see if you agree with it.
I think that'd be a good idea. They remind the commissioners we have a lunch appointment. We're at 12:10 right now.
Yeah, I think we'll be okay, because I'm close to done. The last big issue, and then I think the others are all consent items, yes, has to do with treble damages. As I said before, if the person who takes the property does so fraudulently, they can be charged treble damages as a penalty for that fraud. If that arises with the person with a superior right suing the transferee directly under the provision that establishes personal liability, the treble damages go to the person with the superior right. So, hey, there's no probate open. You took that out of probate, and it should have come to me. I sue you, and I prove it, and I prove that you did it fraudulently. I get the property, I get treble damages. That's existing law. The clawback provision, where the estate says, hey, you shouldn't have taken that, it should have gone to your brother, we're recalling the property so that we can give it to him. In that situation, the treble damages go to the estate under existing law, not to the person with the superior right. So the tentative recommendation asks for comment. Is that the right result? Is that justified? In their first letter, Texcom suggested as a general principle that the treble damages award should go to the person who was most harmed by the fraud. And so it makes sense if the superior right claimant is bringing their own lawsuit to vindicate their own right that they get the treble damages. Also, there's nobody else in that situation who could, right? And they also suggested that it makes sense that the estate get the treble damages if they go to the trouble of petitioning, or the process of clawing the property back into the estate because it was fraudulently transferred, and they prove up the fraud. And they suggest that in that case, it's the estate who was harmed by the fraud, and in particular, the residuary beneficiaries. So a residuary clause in a will is sort of a catch-all at the bottom that says, and anything else that's not covered by this will to X. That struck the staff as problematic, that it potentially, we saw the point when you claw property back for the payment of debts. Because in that case, it is the entire estate who's been shorted by taking that asset out, because they're left with a greater, undeservedly greater share of obligations. And that's going to hit the residue first because under the rules of priority, the residuary beneficiaries pay debts first before anybody else. So they're going to get wiped out first. And so maybe they are the first and highest injured parties if the estate is deprived of an asset that's needed to pay debts. However, this clawback provision can also be used where there's a person with a superior right claim. And in that case, it struck me that it would be strange for there to be this disparity, that if they filed their own lawsuit, then they're the person harmed and they get the treble damages. But if the estate acts for them, then they're not the person who's most harmed. The estate in the aggregate is, and particularly the residue. And that felt like that could produce windfall situations where residue, it's like, oh, and if there's anything left over, give it to my uncle. And now all of a sudden the uncle gets a treble damage award for fraud that was perpetrated on somebody else who should have gotten the asset and didn't. And that feels disjointed to me. Texcom, in their follow-up letter, seems to agree that there are scenarios where it would be inequitable to give the treble damages to the residue beneficiaries and to the estate where it actually was the superior right claimant who was harmed. And also some weird results where if you gave it to the residue, what if the person who perpetrated the fraud is a residuary beneficiary? So they have to pay treble damages and then it goes back into their pocket because they are the lowest priority person in the will. So they provided some support for the staff's unease with that rule. The thing I would add that I think really strengthens the concern is that the Commission's proposal would limit the clawback provision to superior right claims. That provision could no longer be used for debts. And so the legitimate concern that Texcom raises about the residuary beneficiaries and the estate being the injured party if there's a fraud that deprives them of an asset that can be used to pay debts is gone under our proposal. And it's only the superior right claim that could be used to justify property return, in which case, in all cases, it really would be the superior right claimant and not the residue that was the one who was harmed by this fraud. So my recommendation based on all of that, contrary to whatever further thoughts Texcom might have, is that I think it would make sense to change the law so that in both cases it is the superior right claimant who receives the treble damages award rather than the estate generally. Makes sense?
No, we agree with that.
Okay.
I should just point out, the first letter was not as nuanced as it should have been. So it was contemplating that the superior right claimant would be the person suing, and therefore they would be the ones who received the treble damages. Of course, that makes sense. We didn't envision or didn't think about the case where the state brings a restitution claim on behalf of some beneficiary with a superior right, but we agree the same principles should apply. The superior right holder should be the recipient of the award.
Does any commissioner see it differently?
Could always apportion.
Oh, thank you. Because that was actually a wrinkle that had come up late in the discussion and that had slipped my mind, which is, and I think Texcom also raised this issue in the second letter, which is, well, okay, but there's costs involved in clawback. Shouldn't those be paid out of the treble damages award? If you actually get treble damages, first pay the estate's costs associated with recovering the property, the remainder to the superior right claimant.
So the other thing I was going to suggest on that part, so if it's triple damages, it's easy to do a 1-to-2 ratio. The two parts going to the superior right holder and the one part going to the estate, presumably to cover costs. But you could also include, to prevent the scenario where the wrongdoer is the residuary beneficiary and they wind up benefiting from their own fraud or essentially wiping it out. You can't pay triple damages to yourself. Do a version of an interorum clause and either disinherit them or, otherwise cut them out from people who can potentially benefit from this.
Yeah, I think we could work around that problem. If we did want to preserve some kind of allocation to the estate, we could somehow disqualify the person who perpetrated the fraud, yeah.
Yeah.
Because that's true, because if you're the one, and, you know, some damages go towards the cost,
Right.
and that's all.
So we have the general consensus, I think, that it ought to be, in general, the superior right claimant rather than the estate that receives the award. And now we have the first wrinkle that was, what about first paying the costs of the property recovery proceeding out of that award before it goes on? Is everyone sympathetic with that approach? Yeah. And then the third one would be to maybe replace that concept with some sort of division of the award between a 2-to-1, for example, between the superior right claimant and the estate.
I think I like your suggestion of gross net better. Because then it provides restitution to the estate for actual costs.
Right.
You know, whereas, you know, the ratio that I proposed a minute ago, that can create inequities.
All right, and then you'd have to add language to like carve out the fraud person receiving benefits. So it sounds like you're backing off of that third possibility and more in favor of the second one, which
Actual
is
costs.
actual costs go
the
first.
Yeah.
Is that a position the commission wants to take?
Are we okay?
Okay.
Don't you agree? That's the actual cost. That's a good one.
I agree. I mean, that's consistent with it. The superior right claimant brought the action themselves. They would incur the cost of the action.
Right.
So I think
But if it's the
the
estate.
same, have the same result.
And then there were a couple of purely technical consent items on pages 19 and 20. If anyone wants to talk about them, we can. Otherwise, I'm done.
Okay, and so we're done with the supplement as well, right? So is this a good time to break? Yeah, I guess it is. So we will now break for lunch and convene back at 1:30?
Oh, yeah, probably.
We'll
Yeah.
be back at 1:30.
It
Thank you.
might be a little later than that, but I don't think we're expecting anyone in the afternoon. Yeah.
Okay, see you back at 1:30. Thank you.
We won't, you can eat it right now, we don't care.
Okay, we're reconvening for the afternoon session of the California Law Revision Commission. My apologies to anyone who's been watching online because we are about half an hour behind our predicted return time. But nonetheless, we'll try to catch up. And we're now on to agenda item 5, which is the stock operators in conformity with the Security Registration Act, number 2020-5.
Okay. So first, some brief background, I guess, for commissioners who weren't here before. This study, which is just starting, also arose from the commission's work on RTODDs. The follow-up study that the commission was involved in, the legislature had directed the commission to answer or to study several issues, and one of those issues was whether the use of an RTODD should be extended to apply to an owner's interest in a real property development called a stock cooperative. A stock cooperative is a common interest development, but it's unusual in that a corporation owns the entire real property development, and individual owners own shares of stock of that corporation, and that entitles them to a right of exclusive occupancy in a unit in the development. So the commission in the RTODD follow-up study solicited some comment on the answer to this question, and the commission decided that it was a poor fit. Using an RTODD to transfer this particular interest would be a poor fit because the owner's interest in the stock cooperative is not evidenced by or transferred by use of a deed. RTODD is, of course, a deed. So in the RTODD follow-up study, the commission decided to recommend to the legislature that an RTODD not be made applicable to transfer of an interest in a stock cooperative. However, at the same time, the commission decided that there was a possibility that, as an alternative, this transfer could be effected through the use of an already existing law, the Uniform Transfer on Death TOD Security Registration Act, which is a relatively small, it's a uniform act, which the commission recommended adoption of, back in '98, I believe. And it essentially provides for a transfer on death to a designated beneficiary of a security. It's not unlike what you might have at a bank, where you have a checking account and you have a pay on death beneficiary. There's not a lot to this act, but it does appear that it would apply to an individual owner's interest in a stock cooperative because it applies to securities, and the term security is defined very broadly. So the commission decided to study whether this act could be adapted in some way to make it applicable to the transfer of this stock cooperative interest. So this memo, as it introduces that study, it just provides some background, and primarily the memo lays out for the commission what the staff's proposed procedure would be for going through the study. There are a number of issues that will need to be studied. Those are listed on page 5. These are the issues that the staff was able to identify in the beginning, and there may be others. And in terms of methodology, the staff proposes to do something similar to what it did in the RTODD follow-up study. Because it's a uniform act, and this one, in fact, has been adopted by 48 states at last count. And many of those states have stock cooperatives. So the staff will research whether any of these states have in some way adapted the Uniform Act to make it apply to the transfer of an interest in a stock cooperative. And if they have, what they did, and then look for commentary on how that's worked out, whether it's been successful, whether there's been problems, et cetera. And in addition, and separate from that, we would, of course, seek comment from stakeholders, the boards of stock cooperatives, as well as individual owners or advocacy groups that represent individual owners, like in basically homeowner associations, and see who has what comments, concerns, et cetera, about whether this would work. So that is really all that's presented by this memo, is to ask you whether you have any concerns or questions or comments about this proposed methodology and the study in general.
Looks like we did all the issues.
Is there, okay.
Good.
We're good. Okay, all right, thanks.
Turning to item 6 on the agenda, staff is going to be my trial court restructuring. Part 6 of the study, memorandum 2020-6.
Okay, well, this is the latest of many, many commission staff memos on trial court restructuring. The commission started working on this topic way back in the fall of 1993, right when I joined the staff. This memorandum focuses on the statutes relating to consolidation and coordination of civil cases. The memo begins by providing some background information on trial court restructuring and the Commission's previous work on the topic. I'm not going to repeat all that information here, but I do think it's worth going over some of the basics for the benefit of the new commissioners. There were 3 major reforms of California's court system at the around the turn of the century. The first one was trial court unification, in which the municipal courts and the superior courts in each county united their operations in the superior court, and that happened on a county-by-county basis until eventually all of the trial courts in all of the counties had unified, which means that there are now 58 superior courts, 1 in each county, and there are no more municipal courts. The second major reform was enactment of the Trial Court Funding Act, in which the state assumed primary responsibility for funding trial court operations instead of the counties. And then the third major reform was enactment of the Trial Court Employment Protection and Governance Act, under which trial court personnel became court employees instead of employees of the county. And as a result of these major reforms, lots and lots of statutes throughout the codes became obsolete in one way or another. And at the request of the legislature, it's the Law Revision Commission that's responsible for making recommendations on how to fix the statutes to remove the obsolete material. For purposes of this memo, the key reform is trial court unification. Initially, the Commission's role with respect to trial court unification was to help figure out how to revise the state constitution to make it possible for the municipal and superior courts to unify. The next step after that was to figure out how to revise the statutes to make it possible for the municipal and superior courts to unify. And that involved many different challenges, including how to preserve the special procedures that applied to traditional municipal court cases, which were generally the smaller cases. There was an amount in controversy limit of $25,000. And so there were special rules that applied to those cases. To make those special rules still applicable in a unified court system, the Commission coined the term limited civil case to refer to traditional municipal court cases, and also introduced the term later of unlimited civil case to refer to traditional superior court cases. And so on the Commission's recommendation, the statutes that established special rules for municipal court cases, like economic litigation procedures, were revised to apply instead to limited civil cases in a county where the courts had unified. So under this approach, it wouldn't matter whether you were in a county where the courts had unified or in a county where unification hadn't happened yet. The same procedures would apply to the same kinds of cases. By 2001, unification had happened in all of the 58 counties, so it became possible to further revise the statutes to eliminate most references to the municipal courts. And the Commission right away had a huge bill that not only took away most of the references to municipal courts, but was also focused on revisions that were necessary to update the codes to deal with the other two reforms that I mentioned earlier. But there's just been a slew of issues where a lot of the easy work was done right away. There's a slew of very difficult issues that we had to set aside in that first pass to give more attention. And the Commission has been sort of steadily picking away at the harder issues over the years. Virtually all of the Commission's recommendations on these matters have been enacted into law. So what's still left are the tough ones, and so you have to come into this at the end of the process with the hard issues, and unfortunately you won't be able to see the easier work. One of the leftovers is this consolidation and coordination of civil cases. The processes, the general rules are described in the memorandum. Their coordination and consolidation are similar processes. They're means of uniting two or more separately filed lawsuits to achieve judicial efficiency and save costs. So it's not just, we're not talking about joinder of causes of action. We're talking about joinder of lawsuits that can consist of either one or more causes of action. Consolidation is a way to unite two lawsuits that are pending in the same court if they involve a common question of law or fact, and consolidation can be either complete or partial. If it's a complete consolidation, the lawsuits are merged into a single case. There's only one set of pleadings, there's one case number, and there's one judgment. In a partial consolidation, the lawsuits are consolidated for some, but not all purposes. It could be consolidated for pretrial purposes, but not for trial. They could be consolidated for trial, but not for pretrial, or some variant on those things. Coordination, in contrast, is a way to unite two lawsuits that are pending in different courts if they involve a common question of or law or fact. And the details of the coordination procedure vary depending on whether the lawsuit is considered complex. Most lawsuits are considered non-complex, and the process for coordinating non-complex cases is described in today's memo. It's a two-step process. First, one of the cases is transferred to the court where the other case is pending, and then the transferred case can be consolidated with the other case using the usual consolidation procedure that we just talked about. The coordination process for a complex case is much more complicated than the one for a non-complex case. I have not described that process in today's memo. It didn't seem necessary, just based on the issues that are before the commission. I explained it in more detail in the memo. If anyone thinks at some point that it's necessary to get into the details of the process of coordinating complex cases, it'd be helpful to hear about that later when we open up the matter for discussion. In 2001, when the commission was doing its initial pass-through on eliminating references to municipal courts, the commission recommended revisions of several provisions in the Code of Civil Procedure relating to consolidation and coordination of civil cases. Those revisions are shown in the memo, and they were enacted into law the same year. And it seemed like the commission was done with issues relating to consolidation and coordination. However, just a couple of years later, the commission became aware of a discussion in a CEB treatise which pointed out two things. And the first one was that there was this particular court rule on consolidation of a municipal court case and a superior court case that had not yet been updated to reflect trial court unification. That wasn't of any particular concern to the commission because the commission works on revising statutes and not on revising rules of court. But the same treatise also said that because limited civil cases, like municipal court cases under former law, are tried under special procedures intended to help keep the costs of litigation within the grasp of litigants whose damages are $25,000 or less, it is possible that the legislature, the Judicial Council, or the courts will develop consolidation rules specifically geared to these cases. And when, at this point, I don't remember whether it was the commission or the staff or some combination that saw this CEB comment and put this topic on the commission's to-do list for trial court restructuring. But it's been on that list for a long, long time. And now we finally have time to look at it. In the meantime, the CEB commentary on this topic has changed. And so now the court rule that it referred to previously has been revised, so it doesn't talk about the court rule being out of date anymore. What the treatise now says is that although there are no special rules on consolidation of limited civil cases with cases within the general jurisdiction of the Superior Court, it appears that under Code of Civil Procedure Section 1048A, the trial courts are able to consolidate limited civil matters with other pending matters that involve a common question of law or fact. And then the treatise also includes a note that cites two quite old cases and seems to suggest that the current situation in which a limited civil case can be consolidated with an unlimited civil case is a deviation from past practice. Now, as explained in the memo, it's clear that at the time of unification, consolidation of a municipal court case with a Superior Court case was possible. In fact, why would there be a court rule on specifically that subject if it wasn't possible? So allowing consolidation of a limited civil case with an unlimited civil case, it was not new. It was essentially a continuation of pre-unification practice, which is exactly what the commission was doing. It was adapting the pre-unification practices to work in a unified court system. The current version of the CEB treatise also points out that the court rules governing consolidation and coordination do not differentiate between limited and unlimited civil cases. And it warns counsel, and this is a quote, to keep apprised of statutory developments and changes to the California rules of court as a result of trial court unification, and check local rules for any amendments adopted by individual trial courts to implement unification. So the treatise is still today raising the possibility of statutorily differentiating between limited and unlimited civil cases with respect to consolidation and coordination. And so I did some research to investigate that possibility and to see whether there have been any problems in the area, and didn't find much of interest, which I think is a good sign. It suggests that the consolidation and coordination statutes are functioning reasonably well after unification, and that there may not be anything that needs to happen. I did find an unpublished Court of Appeal decision called Medina versus Cook, which involved consolidation of a limited civil case and an unlimited civil case not long after the municipal and superior courts unified. Cases described in the memo. For the commission's purposes, the key issue was whether the $25,000 cap on damages that usually applies in a limited civil case continued to apply after consolidation of the limited civil case with the unlimited civil case. The Court of Appeal discussed the issue but declined to decide it. The court noted that it was an issue of first impression because unification had just happened. The trial court record was murky regarding the extent of consolidation, whether it was complete or partial. And the party that was arguing that the $25,000 cap applied had failed to raise that argument in the trial court. So the Court of Appeals basically said, you failed to raise it, you can't raise it on appeal. The situation that's discussed in that case, where the extent of consolidation was unclear, seems unusual and undesirable and totally avoidable. The courts can clearly decide one way or another whether you have a single case with merged pleadings or you're keeping your cases separate. If it had been clear that the limited civil case was completely consolidated with the unlimited civil case, such that the two cases merged into a single proceeding with a single judgment, under the rules governing classification and reclassification of civil cases, it would seem inescapable that the merged case was an unlimited civil case, and thus that the $25,000 cap on damages would not apply. Similarly, if it had been clear that the limited civil case was only partially consolidated with the unlimited civil case, it would have been pretty straightforward to conclude that the limited civil case remained subject to the rules that apply to a limited civil case, including the cap on damages. So, back when the Medina case was decided, the statutes governing classification of civil causes had just been revised to work in a unified court system, and so the court at that time was understandably reluctant to reach a new issue on a sort of murky record that when the issue hadn't been raised below. But now the classification and reclassification rules are so well established and been in place for a long time. There might not be any need for any further guidance, at least when the extent of consolidation is clear, and the trying to prevent an ambiguous situation like the one that did come up in the Medina case would really be beyond the scope of what the Commission's role is in this particular study. We're authorized to look for material made obsolete by trial court restructuring and not to fine-tune the coordination and consolidation statutes generally. So where does that leave the Commission? There are a number of options for the Commission to consider. First, in thinking about the Medina case, the staff realized that partial consolidation of a traditional municipal court case, now known as the limited civil case, with a traditional superior court case probably could not have occurred before unification because the superior court lacked jurisdiction of municipal court cases and vice versa. To achieve consolidation of a municipal court case with a superior court case, the municipal court would presumably have to have transferred that case to the superior court, and then the cases would have had to be completely consolidated because otherwise the superior court would be trying to adjudicate something it didn't have jurisdiction of. So if the Commission was going to rigidly stick with its approach of preserving pre-unification procedures in a unified court system, it might be appropriate to propose a statute that would prohibit partial consolidation of a limited civil case with an unlimited civil case. And that is one option for the Commission to consider. As explained in the memo, that kind of restriction might impede realization, I think, of precisely the kinds of efficiencies, judicial efficiencies, that were the whole point of trial court unification in the first place. And so, the staff's recommendation is not to proceed with a proposal along those lines. A second possibility would be to propose statutory revisions that would expressly say how the laws on consolidation apply to a limited civil case. I've given some examples of that on pages 20 to 21 of the memo, something like a limited civil case may be completely or partially consolidated with an unlimited civil case pending in the same court if the usual requirements for such consolidation are satisfied, and then the various other things that I spelled out on those pages. And it would be possible to propose similar revisions of the coordination statutes, and perhaps being explicit about consolidation of a limited civil case and a unlimited civil case, or coordination, might help prevent confusion in some circumstances. It's hard to know. But then the third option for the commission to consider is whether this type of statutory guidance is really necessary at this point. To the staff's knowledge, the courts are generally handling consolidation and coordination matters appropriately without such guidance. There don't seem to be any glaring problems that cry out for attention. And so the staff's advice, recommendation, would be that unless the commission receives input demonstrating the existence of a significant problem with current law on consolidation or coordination of civil cases, and that problem is attributable to trial court unification, so it's within the commission's authority to address it, the staff's recommendation would be to do nothing further with regard to consolidation and coordination, and instead move on to the other projects that are still on the commission's trial court restructuring to-do list. So that's the staff's recommendation on the topic, and I think at this point there's nobody here to say that there is a significant problem with the consolidation and coordination statute. I should let you know, I did, there are attorneys at the Judicial Council who are quite familiar with the coordination process. In particular, they have a person who is specifically assigned to that role. I made sure that they got the memo. They said they would take a look at it. I told them when the meeting was going to be. I have, as far as I know, I checked my email this morning. I forgot to check at lunchtime. I have not heard anything from them since I let them know that the memo was there to take a look at. They're not here, so that's where we stand.
So Barbara, I'm fine with the staff recommendation. My only question would be, is this open-ended? Because, we have a continuing jurisdiction in this sort of stuff. So you're not talking about over the next year or two. It could be someone bringing up something 8 years from now. You would still be able to, right?
I think if somebody came to the commission and said, there's this really problematic feature with the consolidation and coordination statutes, and it seems to be a lingering problem from failure to adjust things properly after trial court unification, I think the commission would always be willing to listen to that person about what the problem is.
Okay, so knowing that there's no time limitation on that possibility, I'm perfectly comfortable with the staff recommendation.
I would just add that I do think the rules of court and the local rules help courts and the clerks. The clerks in LA County will see if two cases are related, and it's really they'll bring it on the judges like desk to sign the court's own motion to consolidate or to court. So I think the courts do a good job already with this, and that's probably why you're not hearing too much on it. But in the event that people aren't clear, maybe in another court or county that doesn't have computerized, or they're not on an electronic file system, your rules might be helpful. Just in enacting or authorizing local courts to make up their own rules, just in the event that there was ever any confusion.
I agree. This does sound like a rule of court scenario.
It's
a rule of court scenario.
Well,
so I'm fine with the staff recommendation.
I am as well, because that's not our purview.
Right.
Commissioner Simpson had a comment?
Yeah, I thought the analysis was very good, and the conclusion sounds correct to me. My only question was, since I don't live in this world too much, when you say you coordinate cases or consolidate cases between courts, is that courts in the same county, or can that be across counties?
It can be both.
Can both, either? Okay.
Yeah.
And then there would be confusion, because then the local rules could conflict with another local rules.
So, but it comes back to rules. local
Yeah,
businesses.
I mean, the basic principle that I would work from here is that the court should, they're a branch of government. They have inherent powers to manage their own business and their own dockets.
Yeah.
So I actually would err in the direction of not over-regulating them.
Yeah, that makes sense.
Precisely to avoid the kind of scenario, to me, it's an advantage that in that one case that you cited, there was some flexibility, like allowing trial courts to have that flexibility to manage their dockets and distribute things as they need to in the interest of justice. I think tying their hands is actually disadvantageous here.
I'm going to remember that for the next one.
So are all the commissioners comfortable with the staff recommendation of
I am.
Okay, that seems unanimous. We'll now move on to item 7 on the agenda, eminent domain pre-condemnation activities, memorandum 2020-7. Okay.
Yeah,
That's fine.
I swear in the witness.
Excuse me. Okay. So we had some discussion of this study at the November meeting. This is about a proposed revision to a section of California's eminent domain law that relates to compensation to an owner for harm suffered as a result of pre-condemnation activity by a condemnor, an entity which is considering whether or not to take the property pursuant to eminent domain and is doing some testing or some other activity on the property. The section is Civil Code Section 1245.060. And again, a brief refresher, the study originated from a decision of the California Supreme Court back in 2016, Property Reserve, Inc. versus Superior Court, in which the court had judicially reformed this section to provide owners with a right to a jury trial as to the amount of compensation that the owner could recover for this harm, consistent with the California Constitution. And as this section had been actually recommended by the Commission a long time ago, after this judicial reform, the Commission undertook this study to recommend a statutory revision of the section to conform to the judicial reform that the Supreme Court had entered. And at the last meeting in November, the Commission approved language to do that. However, in addition to that conforming, during the course of the study, the Commission also decided to look at 3 other issues. Those are listed on page 2 of the memo. The first was whether Section 1245.060 should address whether or not an owner can obtain this compensation before all the pre-condemnation activities are completed. The Commission has since resolved that issue and decided that the section should not address this issue. That's what you decided at the last meeting. The other 2 issues that are still hanging in the study, number 2 was whether the section should preclude an owner from obtaining compensation for prospective harm. This was an issue that had been raised in an earlier memo. Prospective harm meaning harm that has not yet occurred, but with sufficient certainty can be shown will occur in the future. And then the third issue was based on a suggestion given to us by Norm Mattioni, who I'll talk about in a little bit. He suggested that the Commission propose a revision that would allow an owner to claim this compensation as an alternative to claiming it in the statutory procedure in 1245.060, to instead have the option of being able to claim it in the subsequent condemnation action. In other words, after the pre-condemnation activity is completed, almost always, according to Mr. Mattioni, he says he's never seen a situation where there wasn't then a direct condemnation action which was initiated by the entity. At least that's what he says. It happens often in any event. And so his suggestion was, should the owner be allowed to alternatively assert the claim for compensation for the pre-condemnation harm as part of the direct condemnation action that followed? So this memo addresses the second issue about prospective harm, and then also this procedural issue about whether the owner can have an alternative forum for seeking this compensation. So prospective harm, the staff's research indicates that prospective harm is generally a compensable element of damages in most civil actions, including in a direct condemnation or an inverse condemnation action, which is also an eminent domain proceeding. And while we found no appellate authority discussing this specific point, because it's recognized as a general element of damages, we saw no reason why it wouldn't be appropriate, or any policy reason why it wouldn't be appropriate to, well, let's put it this way, to not preclude it in any event. The staff's recommendation is not to say anything about the issue. The request was, or an issue that was raised was whether the statute should expressly preclude it, and the staff's recommendation is no. It should be treated like damages in any other action. If it can be proven with sufficient certainty, then that would be an appropriate element of damages for the owner in the whatever form it was that the owner was able to recover damages. So does the commission see that issue otherwise, or is that agreeable with the commission? Basically, the recommendation is not to address this issue in this recommendation that we eventually give to the legislature.
Am I looking at the wrong thing? I thought the recommendation was to codify the case law rule.
It's the next issue.
That's the next issue.
My bad.
Sorry, okay. This is just about, this is a smaller issue, which is just about whether, okay. Nothing else? Okay, fine. Okay, great. So now we come to the third issue, which is this procedural issue. Where did my pen go? There we go. Okay. Norm Mattioni is an eminent domain attorney, a longtime attorney. He's an author of a treatise on the subject matter of eminent domain proceedings, and he was, a while ago, was a consultant to the commission on the subject. As I indicated, he had suggested that there be this alternative for the owner. There is a statutory procedure in 1245-060, but his suggestion was that it might make more sense and the procedure might be more efficient overall if the owner was allowed an opportunity to instead seek this compensation in the direct condemnation proceeding. This seemed like it made some sense to the staff, and this is particularly true because in Property Reserve, Inc., the Supreme Court had said that the owner gets a jury trial on the amount of the pre-condemnation harm, and also would have a jury trial right, of course, in the direct condemnation action. So the thinking is, why would you need to have impanel two juries and have two juries decide this separately? It might often make sense to do it all together, which certainly, you know, made some sense to us. But, you know, we found no appellate authority addressing the issue at all. So, you know, we went further to see if there was other support for this. And there is support in two different ways. First, there is a different type of pre-condemnation harm in eminent domain law, which is called clopping damages. Clopping is the name of another Supreme Court opinion. These are not damages caused by activity on the property. Clopping damages are damages that harm an owner suffers when the entity, the prospective condemnor, unreasonably delays in commencing the condemnation action after publicly announcing it, or does some other unreasonable activity prior to the commencement of the action. The problem is that once it's announced, then property value can start going down. There can be other harms to the owner, and so the owner, loss of business, et cetera. So in 1972, the Supreme Court in its clopping decision said that that's also compensable harm for an owner, in addition to the value of the property, which is generally what's at issue in a condemnation action. In clopping, the Supreme Court said not only are these compensable damages, but that they can be sought in a direct condemnation action as well. That can be part of what's at issue in the direct condemnation action. So because this is another type of pre-condemnation harm, it seemed to the staff that was support for finding that it would be appropriate to allow pre-condemnation harm based on 1245.060 to also be alleged in the direct condemnation action. And then finally, actually, the commission, when the commission recommended the enactment of 1245-060 to the legislature, also appears to recognize that this would be appropriate, because there's a comment to that section which indicates that if an eminent domain proceeding is eventually filed to take the owner's property, the owner may recover for those damages under 1245-060 by a cross complaint in the eminent domain proceeding. So, and the language in the comment is a little bit stronger than that, but it clearly recognized that there was the owner would be in this direct condemnation proceeding and would be allowed to make a claim for this pre-condemnation harm in the direct condemnation proceeding. So, with Mr. Mattioni's request, and he has some considerable expertise in this, the way that clopping damages are treated in terms of being allowed to make the claim in a direct condemnation action, and the commission comment, it seemed to the staff that at least for inclusion in a tentative recommendation, which is where we are in the study, that it would be appropriate to recommend a revision of some kind of 1245-060 that would make clear that an owner can seek compensation for pre-condemnation harm in the direct condemnation proceeding as an alternative to the statutory procedure. So there's still a pleading issue to talk about, but before we get there, does the commission feel differently about this issue, about whether the alternative should be provided generally in the direct condemnation action, or is there questions about how this,
Any commissioners?
I care about the civil procedure aspect of this.
I'm sorry?
I care about the civil procedure aspect of this.
Okay, good. So we'll get to that.
Leading question.
Right.
Let me just make one point of clarification, because I'm looking down the road to preparing minutes for this. Steve said that he was asking about making a proposed revision to 1245-060 to address this. I would just say that we're not yet sure whether that's the right location to make a revision. The substance is the same. I just don't want to tie our hands by getting a commission decision that specifies a particular provision.
Right. I agree completely. In fact, it probably would not be part of that section. It would be in another section.
Probably in the general law on condemnation.
Yes.
So this would just simply be examining this particular issue without reference to a section?
Yeah, just that the commission wants us to develop a proposed reform that would make clear that 060 damages can be sought in a subsequent condemnation.
Yeah, in the answer specifically.
Well,
Well,
no,
that's the
we're
next
not at the
decision.
pleading
We're
issue.
going to
Not yet.
have a discussion on that.
I really want to get to that. Can you tell?
Ready? You seen that? I have a.
Ready? All right, here we go.
I actually have an opinion on that.
Okay, good.
Okay. So thank you, Brian. And so now we come to the pleading issue, which is whether this claim for compensation should be sought by the defendant owner, because the owner is a defendant in a direct condemnation action, in the owner's answer to the condemner's complaint, or should the owner be required to file a separate cross complaint in that action? So,
You can go first. You're the chair.
Well, he's going to make a recommendation. Well, actually, the recommendation is that we're 50-50, but you kind of come on one side. But there's a good argument for either side.
I thought the recommendation was to codify the case law.
well,
He wants to discuss it, and then we could have viewers. Actually, my friends are watching.
Are they really? Okay.
Yeah, why don't you go through a recommendation? I thought your recommendation was it could go either way, but here's one way that it could go.
But Commissioner Dunfield, we're just trying to make.
Just totally hijacking this.
Please proceed.
So, yeah, Steve, finish your presentation.
I'll try to be.
Yeah, I wouldn't jump to the recommendation because there's some interesting history
Yes.
on
No, I won't do that. I will try and be more prompt or brief or something. I don't know. All right. So there's two things to look at here. The staff, in trying to determine which pleading would be appropriate. First, the staff considered the nature of pleadings in general in a direct condemnation action. They are different than in typical civil actions. This wouldn't even be a question in a typical civil action, because an answer in a typical civil action is a response or refutation of whatever the plaintiff is alleging, and you actually are prohibited from seeking affirmative relief in an answer. In a direct condemnation action, that's not the case. In fact, in the answer, the owner is required by statute to identify the nature and extent of the interest the defendant owner claims in the property described in the complaint. And another subdivision requires them to include any claim compensation for one particular type of harm, loss of goodwill. And in fact, in eminent domain law, at least specific eminent domain law, there's actually no provisions at all about the content of a cross complaint. And my understanding from looking at treatises is they're relatively rare. There are other reasons you can use a cross complaint, but and it's certainly allowed, but apparently it's not often used. And there's no specification in the eminent domain law about what a cross complaint has to include. So, because the defendant owner is already claiming compensation as part of the answer, it seemed to make, at least logically, it seemed to make sense that the claim for compensation for pre-condemnation harm, which is related to this property, might go in the answer, but not necessarily, because it could go in a cross complaint. So we didn't have a clear answer based on just looking at the pleadings. So then we went further to see what else we could find. Again, this issue is not addressed by any case law, because the specific issue about 060 damages being, we couldn't find even a case law allowing it to be claimed at all in direct condemnation action, so the pleading question we couldn't resolve. But what we did look at was how clopping damages, the damages I just talked about, how those damages are to be pled in a direct condemnation action. And unfortunately, it was not completely clear. The answer to that is completely clear. So the clopping opinion itself, which was decided in 1972, did not address the pleading issue. It just said you can claim these damages in the direct condemnation action. The commission was right at that time working on eminent domain law, and after this decision, the commission wanted to address this issue about what the pleading should look like. They thought it would be a good idea, although they didn't end up putting it in a statute. What happened was they got public comment. There was another eminent domain consultant who said, put it in the answer. You can have it should be part of the whole claim to compensation overall. But the commission was not persuaded, and they included in a comment in the general civil law relating to compulsory cross complaints that in an eminent domain action, clopping damages would be claimed by a cross complaint. That would be the vehicle to use for clopping damage. It's not part of the statute, the statutory language, but it's in a comment.
It goes a little bit more than that, because in the same recommendation, we recommended, and it was enacted, an amendment to the rules on cross complaints. We recommended, and it was changed, that they were made applicable to eminent domain proceedings. And the comment to that provision, I think, referred to clopping.
Yes, that's what I'm talking about.
So the statute itself wasn't expressly amended to say this kind of action is a cross complaint, but they made those provisions applicable to eminent domain purportedly with a reference to clopping. So there's an implication there.
Previously, before that new section, the rule about compulsory cross complaints was not applicable to eminent domain proceedings. And so the amendment made that rule about compulsory cross complaints applicable to eminent domain proceedings. And then the commission in the comment offered as an example that clopping damages might be that type of cross complaint. So, however, so that was back in 1973, 1 year after the clopping decision, before there had been any appellate decisions addressing this issue. Well, then some appellate courts started addressing the issue, and we didn't find any appellate court that mentioned the commission comment, but there appears to be consensus authority. It's not, I mean, there's no dispute about it. There's not like hundreds of cases, but all the cases we found that addressed the issue said the pleading should be in an answer. And Mr. Mattioni says that for clopping damages, it's now pretty much accepted practice that clopping damages get pled in an answer rather than in a cross complaint. Now, again, we're not talking about clopping damages here yet. We're talking about another kind of pre-condemnation harm, but there's a pretty strong analogy that can be drawn.
And he says our commentary on clopping is a source of confusion within the practice,
Yes.
because it says cross-complaint and the case law says answer.
So, I think I'm mostly there. So that's kind of like where we are now. As is indicated in the memo, you could make a reasonable argument for either pleading. But it seems likely that practitioners now are using the answer. That seems to be the consensus case law. No one's talked about the comment. And so if we were to now switch and go to some different practice for the 1245-060 damages, there would be some confusion about that, I would think. In fact, the staff's recommendation is not only to allow the 1245-060 damages to be pled in an answer in the direct condemnation proceeding, but as a separate recommendation, the staff thinks it might be helpful to clarify in the statute that clopping damages also should be pled in an answer in a direct condemnation proceeding. So, questions, comments? Commissioner Carrillo?
No.
Okay. I'm all for that. I think there's one element that you haven't discussed, because I spent part of the early 90s doing these condemnation cases from the defense side. I would prefer the answer. It works in the answer. You have other damages in the answer. And it's not an easy thing to say, well, just go ahead and file a cross-complaint. Because once you file a cross-complaint, someone has to file the answer to the cross-complaint. Right. Yeah. So, the whole purpose of this condemnation law is to have, no liability, you just go to damages. We're trying to lessen the burdens on the courts. So although, people can flippantly go like, well, it could be in a cross-complaint, cross-complaints cost money, and answers to cross-complaints cost money.
Right.
And it really isn't that common to have cross complaints.
So why guarantee 2 extra pleadings in a file that's already full? And as a additional practical matter, you know how this will play out in the real world, that people will try to settle the original legal action and then go, if you don't settle this legal action, I'll file a cross-complaint.
Yeah, that's.
That's automatic. So it's going to be used as a bludgeon tool to say, well, come up 10,000 more, because I'll just file a cross-complaint, and then you have to hire someone to file the answer to the cross-complaint, and it'll cost you 5,000. Why don't you give me 10,000 more? And so just for those practicalities, I'm a strong advocate for answer.
I agree with Victor.
Totally agree. The one additional thing that I would add is, can we get rid of this comment that is apparently causing lots of problems?
It's in the past, right?
Comments are
Can we
forever.
do a new one and disclaim it, overwrite it, and point them to the new
Pay no attention
changes?
to that comment.
Yeah.
We could just say that the comment to whatever reform Steve works up could say that the change that we're proposing is consistent with this case law, which superseded somehow the commission's prior commentary.
Right.
But
To me, that absolves.
It's in the record. There's really,
I think we have to address it.
Another possibility, but I don't know that there's any way to make this work. If there was an amendment to the section to which there was this comment, then we get another comment, which follows right below it.
Great.
But I don't know that what we're talking about here would, yes, it would.
Yeah.
I mean, it's not really related to what we're doing. I mean, in a sense it is, but not, it's not necessary, I don't think, to effectuate that. It would be like we would be making it up almost.
Commissioner Simpson.
I'm just curious. I guess I think I'm persuaded by your description. But is there any reason why a statute couldn't say you could do either? Why would you have to pick one?
May I?
Oh, that's an excellent point. Whether you're precluded, are we
Yeah.
going to go down that
Well,
road?
that is what the suggestion is, that there's alternative relief. or.
Wait.
I was reading as
No,
a
you're
cross-complaint is
talking about
still
either
available.
answer or cross, you're talking about either pleading, right? You're not talking.
Correct. No, I'm saying, why couldn't your request for damages as part of the direct condemnation be put forward either as a cross-complaint or as a response to the...
You may not need the cross-complaint. So if all you have is damages of whatever flavor, those properly and most efficiently and according to the case law go in the answer. You may have other claims that you want to raise, so that's why having the option of not ruling out a cross-complaint is better. I mean, what if you wanted to allege, I don't know, intentional infliction of emotional distress or something like that? That definitely shouldn't go in the answer. That's a whole separate.
Right.
Exactly, it's a
So-
separate
Yeah.
board.
That was a comment I was going to make, that when you invite people to put it in a cross-complaint, you're almost inviting them to think of other causes of action. It's like, gosh, I'm going to have to file a cross-complaint. It's a real pain in the ass. Well, why not throw in something else? And so we're not precluding cross-complaints. If you have a legitimate cross-complaint for something of a non-damages nature, you can do that. But we're saying, just for certainty, and again, the reality of these cases is that they're negotiated out. These cases are always settled for the most part. You want everybody to just upfront, in the initial pleadings, say what the problems are and what the damages are. You make a cross-complaint, you got some tolling on that, people come up with new ideas, and it's just going to exacerbate the process, increase damages overall. And so I still think that the damages part should be in the answer, but of course, we're not making a comment on blocking cross-complaints in general.
Okay, great, because I think that was your point, is that were you concerned about whether if you failed to put it in the answer and then raised it subsequently in the cross-complaint that you would be barred? Was that?
No, I had no idea what that is.
Oh, okay, okay, sorry.
No, but my question was, as a procedural matter, if it works, if it accomplishes the same outcome as a procedural matter, whether it's in a cross-complaint or the answer, why do we need to choose other, I mean, you're saying there's
The transaction
political,
costs of a cross-complaint,
but isn't that a choice that whoever's making the pleading makes?
The choice, as I understand it, is where to put damages. That's 90% of.
Yeah, which we're,
Yeah.
I have no question.
Yeah.
It's part of the direct
Yeah.
action as
And
well.
so I agree with the staff recommendation that for several good reasons, it makes the most sense to put damages in the answer. And to me, that's not really a choice. It makes far more sense to put it in the answer than in the cross-complaint. And it reverses when you're talking about non-damages, like literally any other kind of claim you could file. It makes way more sense to put them in a cross-complaint than in the answer. So it's a choice, but it's dependent on the type of relief that's being requested.
Okay.
There's an appropriate vehicle for each one.
Barbara?
Yeah, so I think what Commissioner Simpson is saying is that instead of having a hard and fast rule that it always has to be in the answer, if there was a situation where somebody was going to file a cross-complaint anyway, and they chose that they wanted to put it in the cross-complaint, because that's normal procedure in civil cases, is you put your claims for affirmative relief in the cross-complaint, and they did that, should they, do you want to have a hard and fast rule that they screwed up, they didn't put it in their answer, and now they're out of luck because they put it in the cross-complaint instead of putting it in the answer?
That
Well,
was my point. I don't think
I
that's
think it
what
would
you're
cause
asking for.
confusion. I think there would be a
Yeah,
fair amount of confusion.
it would invite people to increase their damages for the purposes of ginning up a cross-complaint. So I'm just saying for expeditiousness, for certainty, don't forget there's a whole infrastructure of risk managers and insurers and reinsurers that have to deal with these cases, and you want valuation up front. And so you want people to just say, here's what I'm out, here's what I want. And then the negotiations start, and these cases disappear before they ever get to the court. And so I'm just very wary of creating mechanisms that create more pleadings that might drive these cases to stay in court, when the reality is if people make reasonable demands at the start, people negotiate it, people want to build their buildings and condemn their properties, and just they dispose of the suit more readily if everybody's up front on top, rather than giving them time to file a cross-complaint, another month to file an answer, and then for the transactional costs of filing a cross-complaint, it's going to cost you at least $5,000 to prepare one, including the filing fees. You're going to go like, well, I'm going to gin up some more damages because I have to make up the fact that I have to spend $5,000. So for all those reasons, I just think it's just so sensible to be in the answer.
Well, I think the question that was before us, and I think was posed, was do we codify the holding and clopping to allow the claim for damages in the answer? And then the subsequent step was drafting some language. And am I correct in that And maybe that's what we need to do, is agree as to whether we want to codify that particular holding so that damages can be asserted in the answer, and then see what we come up with.
Well, Cochran didn't address the pleading. Cochran
True.
said you get to recover in the subsequent condemnation.
Okay.
So the pleading is the other sources of authority that we would codify, subsequent case law that talking about the application.
Okay, but it still is something that's in case law, the same principles,
Yeah,
so.
and I agree that that's the call of the question. Discussing what makes good best practices is a whole different issue.
I think we just need to,
I agree
get
with
to the
you,
next step,
Victor.
which is seeing what the language is gonna look like and have.
We'll be able to approve it and disagree
Correct.
with it.
That's the
So I
next
so I guess
step.
maybe the direction you need is, do you want us to authorize you to start drafting something that would put these things in the answer? And then, of course, we could agree not to pass it later if there are other concerns.
Well, I mean, we should give deference to the practitioner. I agree with you both. It doesn't make
Oh,
sense to
absolutely.
file a cross complaint when you should just put the answer or.
But we have to
the
make
answer.
steps towards.
And for non-attorneys, just because you don't have it in, you don't have the exact amount in the answer, you can amend the answer, you have discovery that qualifies what you say in the answer. It's not a bar, that whatever you wrote in the answer is the be-all and end-all.
Right. So that was the next step, is for you to see the language. And I guess the only question is, there's already been one early TR, a tentative recommendation in this case. We got some public comment. It was just about on the issue of how to revise the language to reflect what Property Reserve Inc. said. So we're going to be doing a revised tentative recommendation here, which would contain all the commission decisions to date. Do you want to see it in a tentative recommendation at the next meeting, or do you want to just see a memo that just has this language before we get to a tentative recommendation?
Just do a memo, Steve, I think, right?
Well,
I was going to suggest the tentative recommendation,
Exactly.
because these reforms are severable. So if you decided you didn't like this piece, it'd be very easy to just execute.
well, let's put it this way,
that's
are you going to
perfect.
be ready to put together the whole tentative recommendation? I mean, what's
Yeah,
your
there's
workload?
not, I don't think there's not that much. There's been two decisions that don't do anything. So the only revision is the change in the language to reflect the jury trial, and then this.
Okay, then I'd like to see the whole tentative recommendation. We can pull it out and discuss it at length if we need to.
It makes
It
it
sounds
easier
like
for
it's the
you
most
to-
efficient method to do it.
Okay, that's the will of the commission then. A tentative recommendation next will contain all the commission decisions to date, then, including today's decision. Thank you.
If seeing nothing else on item 7, our last item of the day is number 8, recodification of the toxic substance statutes, memorandum 220-8 and supplement.
Thank you. So that's mine, and that is the bulk of your paper today, I believe. I almost got to a ream, not quite. So what you have before you today are 2 tentative recommendations. And so I'm going to take the one that's attached to the main memorandum first. Over the course of the commission's last several meetings, we have presented preliminary drafts to recodify Chapter 6.8 of Division 20 of the Health and Safety Code. At the last meeting, the commission actually approved the draft for the last of those existing provisions, placing those in this new sort of statutory organization that we've proposed. So for the most part, this is essentially, the statutory language is all stuff that the commission has seen before, just put together. We've made a few minor refinements that are discussed in the main memorandum. At this stage, it's our tentative recommendation. So attached is the draft tentative recommendation that includes, the new stuff is a preliminary part, a narrative discussion of what's presented. For these types of studies, this is a non-substantive recodification. Our preliminary part is very sort of standard. It looks very similar to the other non-substantive recodification studies the commission has done recently. So there's really not a lot I have to discuss today. I just need a decision on whether or not the commission wants to approve this as a tentative recommendation to be circulated for public comment. But I'm also open, if the commission has any questions or wants to discuss anything, we can jump into those items.
Do you have a motion to approve this?
I'll make that motion.
Second.
All right, all those in favor say aye.
Aye.
Anyone opposed? Any abstentions? Seeing none.
Okay. So getting to the second of those, I do want to mention one thing. So we have set a comment deadline. It's relatively lengthy for this because it's quite a bit of statutory material. And I have done that in consultation with the DTSC staff. They weren't able to be here today, but I do think that comment deadline is going to work for them. So the second draft tentative recommendation is the conforming revisions, updating all of the cross-references that currently point to Chapter 6.8 or its contents. This is very technical. They're essentially just striking out existing cross-references, putting in the new number. We made a few minor legislative drafting updates to the provisions we were touching, but that's about it. And in this case also, all I need is a commission decision approving the draft. I should mention the subordination clause that Brian discussed earlier. That is something that we routinely include in these types of drafts, and that is in this draft as well. So,
Do I hear a motion for approval?
Move approval.
All those in favor say aye. Aye. Anyone opposed? Any abstentions? Seeing none, I believe we're done. Any other comments or concerns? For the good of the body, I'll go ahead and dismiss the meeting. Thank you.